Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends, and thank you so much for coming to hang out with me on this pre-recorded video today, which is something I never do, but it's very, very late, and this decision broke today, and I wanted to get it out to you. So here I am pre-recording. Today is Thursday, December 26th, 2024, and an Ohio appeals court has overturned the conviction of Sidney Powell and has granted her a new trial. Very interesting stuff. You may recall that in March 3rd of 2020, college student Sidney Powell, who was 19 years old at the time, took the life of her mother in the kitchen of their Summit County home in Ohio. She had been kicked out of the college that she was attending at the time, the University of Mount Union, and she had failed to tell her parents that she had been kicked out of college. And while her mother was on the phone with school officials in the kitchen of their home, she struck her mother with a cast iron skillet and stabbed her over 30 times. The defense at trial was not guilty by reason of insanity. And during the 3-week trial, the jury considered 3 verdicts: guilty, not guilty by reason of insanity, or not guilty. Ultimately, they convicted Sidney Powell of 2 counts of murder, felonious assault, and tampering with evidence. In September of 2023, Judge Kelly McLaughlin sentenced Sidney to life in prison with the possibility of parole after 15 years. Immediately following her sentencing, Powell appealed her conviction. The appeal centered on 4 arguments, but in its decision, the appeals court focused only on the first. The trial court committed an error by preemptively barring the defense from presenting a rebuttal case. Let's take a look at the decision. And this is out of the Court of Appeals for the 9th Judicial District of Ohio. And the case is the state of Ohio versus Sidney Nicole Powell. Dated today, December 26, 2024. Decision and journal entry. Sidney Powell appeals her convictions in the Summit County Court of Common Pleas. This court reverses. After graduating high school, Ms. Powell enrolled as a first-year student at Mount Union College. Mount Union placed her on academic probation after her first year, and after her academic performance did not improve, she was placed on academic suspension after the first semester of her second year. Ms. Powell did not tell her family or friends. Instead, she returned to campus in January and moved into her residence hall as though nothing had happened. After Ms. Powell's sorority president questioned why her name did not appear on a membership roster, the Associate Dean of Students contacted Ms. Powell. Although Ms. Powell initially denied that she was suspended, she eventually acknowledged that she was aware of the suspension. The Associate Dean set a timeline for Ms. Powell to move out of the residence hall, and Ms. Powell agreed. When the deadline passed, however, the Associate Dean learned that Ms. Powell was still living in the residence hall. During a second meeting between the official, Ms. Powell, and the Vice President of Student Affairs, Ms. Powell acknowledged that she was required to move out, stated that her parents were aware of her suspension, and represented that she just needed more time to do so. Yet again, Ms. Powell did not move out by the deadline. When staff approached her in the residence hall, she refused their offer to contact her parents and moved her belongings out immediately. Over the next week, Ms. Powell stayed in local hotels, visited her home when her parents were not there, and sent text messages to friends. On the evening of March 2nd, 2020, Ms. Powell returned to campus and watched The Bachelor with her friends. When Ms. Powell returned to Mount Union in January, her father, SP, I noticed they're not naming the parents in this appellate decision, noticed that he could not access the parent financial portal. When he asked Ms. Powell about the problem, she told him that she would take care of it. On the morning of March 3rd, 2020, SP received a call at work from Mount Union informing him that Ms. Powell was no longer enrolled and directing him to Ms. Powell for further information. Using a location sharing app on his smartphone, SP noted that Ms. Powell was at home at a time she should not have been there. He left his phone at work so that Ms. Powell could not track his location and drove to his home where he found Ms. Powell. During the conversation that followed, Ms. Powell expressed frustration that her friends seemed to have figured out their lives while she had not. SP urged her to talk to her mother, BP. One of them contacted BP, who told her coworkers that she needed to go home to deal with a problem involving her daughter. SP returned to work before BP arrived. At 12:36 p.m., BP sent him a text to confirm that she was pulling into the driveway. On March 3rd, 2020, the Dean of Students at Mount Union received a message that BP had called to discuss Ms. Powell. The note that the message was written on also said that Ms. Powell was sitting next to BP when she called. The dean asked the associate dean to join him for a telephone conversation with BP, and they returned the call from his office. BP answered the call and they identified themselves. The conversation did not progress any further. At that point, they heard a thump or a thud that was accompanied by a pretty large scream. After that, they heard an expulsion of air, like the air was knocked out of somebody, the sound of the phone falling to the ground, and a number of thumping sounds that went on for maybe 15 seconds or so. They heard crying and screaming that seemed to get further away and then to approach the phone again, followed by sounds like a hard item hitting something. When the call dropped, they tried to call back. On the third attempt, within about 1.5 minutes later, a very calm voice answered, but the dean recognized that it was not the person he had spoken to before. When he addressed Ms. Powell by name, the call dropped. The associate dean contacted the Akron Police Department directly to avoid being routed through Stark County's 911 system, and officers were dispatched for a welfare check at Ms. Powell's residence in response. At 12:51 p.m., SP received a call from his lifelong friend, Detective Kenneth Deese. Detective Deese had recognized Detective Deese had recognized SP's address in radio traffic, and he informed SP that officers had been dispatched to his home for a welfare check. SP attempted to reach BP unsuccessfully, but he did speak with Ms. Powell, who told him that BP was on the phone with officials from Mount Union. When SP told her that police were on their way to the house, Ms. Powell lost her composure and told him that someone had broken into the house. When the officers arrived, they heard a woman crying for help. In the back of the house, they found that a window was open, a sliding glass door was ajar, and there appeared to be blood on the vertical blinds. One of the officers found Ms. Powell, who was yelling that her mother was in the back of the house. According to their testimony, Ms. Powell told them that after hearing a noise, her mother told her to leave the house. She told the officers that when she heard screaming, she went inside and found her mother on the floor. The officer noted that Ms. Powell had cuts on her own hand that were actively bleeding. The officer found BP in a bedroom lying face up on the floor. A cell phone, a large cast iron skillet, and a knife were found near her body. BP died as a result of her injuries. Ms. Powell provided her name to the officers outside the house, then dropped to the pavement and stopped answering questions. Remember that body cam footage? It was chilling. Although she was transported to the hospital by EMS, Ms. Powell quickly became a suspect in BP's death. She was involuntarily admitted to Akron General until March 16th of 2020 after an emergency psychiatric evaluation. Ms. Powell was charged with 2 counts of murder and 1 count each of felonious assault and tampering with evidence, and entered a plea of not guilty by reason of insanity. Before trial, Ms. Powell moved the court to permit her to call witnesses to rebut the state's anticipated expert testimony related to the not guilty by reason of insanity defense. The trial court denied the motion during trial, but before the state's expert testified. After the state's expert testified, Ms. Powell renewed the motion, arguing that her experts could have rebutted specific points related to the methodology used and conclusions reached by the state's expert. The trial court denied the motion again, concluding that Ms. Powell had lots and lots of expert testimony in this matter. And that's in quotes. The jury found Ms. Powell guilty of all the charges against her. The trial court determined that the 2 counts of murder and the count of felonious assault were allied offenses, and the trial court sentenced her to an aggregate prison term of 15 years to life. Ms. Powell appealed, assigning 4 errors for this court's review. Assignment of error number 1. The trial court committed prejudicial error and violated Ms. Powell's fair trial and due process rights when it preemptively barred her from presenting rebuttal witnesses. We don't see rebuttals very often, so this is a very interesting decision. Ms. Powell's first assignment of error raises 2 arguments regarding the presentation of evidence to rebut the testimony of the state's expert witness. The trial court erred by denying her pre-trial motion, and that the trial court erred by refusing to permit rebuttal after the state's expert testified. This court agrees in part. So this is the only error that they're going to consider, and this is the error on which they are going to reverse Sidney Powell's conviction and grant her a new trial. The sanity of a criminal defendant is an affirmative defense, not an element of the charged offense. A person is not guilty by reason of insanity only if the person proves that at the time of the commission of the offense, the person did not know, as a result of severe mental disease or defect, the wrongfulness of the person's acts. Because the defendant must prove not guilty by reason of insanity by a preponderance of the evidence, quote, the proper standard for determining whether a defendant has successfully demonstrated this defense and thus is entitled to a not guilty by reason of insanity instruction is whether he has introduced sufficient evidence which, if believed, would raise a question in the mind of a reasonable person concerning the existence of the issue. Revised Code Section 2315.01a explains the order for the presentation of evidence in a trial. After opening statements, the party who would be defeated if no evidence were offered on either side first shall produce that party's evidence, and the adverse party shall then produce the adverse party's evidence. After each party presents its case in chief, the parties shall then be confined to rebutting evidence unless the court, for good reasons and in the furtherance of justice, permits them to offer evidence in their original cases. Because it is an affirmative defense, Ms. Powell bore the burden of demonstrating that she was not guilty by reason of insanity by a preponderance of the evidence. Not guilty by reason of insanity was an issue on which Ms. Powell would be defeated if no evidence were offered on either side. For purposes of not guilty by reason of insanity, the appropriate time for Ms. Powell to present her evidence was during her own case in chief. After Ms. Powell's case in chief, the state could present both rebuttal evidence with respect to its own case in chief and, as the adverse party with respect to not guilty by reason of insanity, the state could also present its own evidence on that issue. After that, Ms. Powell could present rebuttal evidence on the issue of not guilty by reason of insanity, if appropriate. So, consequently, as the substance of Ms. Powell's argument recognizes, the question before this court is not whether the trial court abused its discretion by denying her the ability to present surrebuttal evidence, but whether the trial court erred by concluding that she could not present rebuttal evidence in the first instance. Rebutting evidence is that given to explain, refute, or disprove any new facts introduced into evidence by the adverse party. It becomes relevant only to challenge the evidence offered by the opponent, and its scope is limited by such evidence. To be presented as rebuttal evidence, testimony must meet two criteria. It must be a matter that was first addressed in the opponent's case in chief, and it should not be a matter brought in the rebutting party's case in chief. When both criteria are met, a party has an unconditional right to present rebuttal testimony. With respect to expert testimony, rebuttal is not testimony that was or should have been raised in the plaintiff's case in chief. Rebuttal testimony is not merely a restatement or a repeat of the expert opinion first given by the plaintiff's expert in the plaintiff's case in chief. This presentation is not warranted merely because the defense expert gave an opinion contrary to the plaintiff's expert. A party need not preemptively counter an opponent's argument, however. Consequently, when an opposing expert offers an alternative explanation, it becomes material after that expert testifies and is the proper subject of rebuttal testimony. This is true regardless of whether the explanation offered by the expert was also posed as a theory during cross-examination of another expert. In her case in chief, Ms. Powell presented testimony of 3 expert witnesses. After each expert testified, the state conducted a brief cross-examination. Dr. James Reardon, who practices forensic psychology, testified that he met Ms. Powell on 2 dates for 8 to 10 hours of evaluation, and he described the psychological assessments that he administered to her. Dr. Reardon explained that psychological assessments function as a check on the individual performing the evaluation, and he explained that he would not be comfortable diagnosing a severe mental disease without conducting assessments. As a result of his evaluation, Dr. Reardon determined that at the time of the murder, Ms. Powell was suffering from a first episode of schizophrenia and a major depressive disorder single episode, which he characterized as both severe and accompanied by psychotic features. Dr. Reardon testified that at the time she committed the murder, Ms. Powell was in a psychotic state or out of touch with reality and unable to know the wrongfulness of her acts. Dr. Reardon further explained that her schizophrenic and psychotic episode was preceded by early indicators of onset that can be noted in retrospect, but that would have been difficult to detect at the time. Contrast this with the Carly Gregg case. Sidney Powell was 19 years old. This case happened in Ohio. Carly Gregg was 14 years old. She was convicted in Mississippi, tried as an adult, and sentenced to life without the possibility of parole. They're very similar to me, these cases. Let me know what you think in the comments. These included a deteriorating connection to reality over the 6-month period of time before the murder, decreased concentration, social withdrawal, and depressed mood. Dr. Reardon opined that by the time Ms. Powell returned to campus in January of 2020, she was on a real slippery slope in terms of her mental and emotional state deteriorating, and noted that she was well on her way to a final psychological decline that was ultimately precipitated by Mount Union's action. He explained that in the week before the murder, Ms. Powell actively manifested auditory hallucinations and exhibited behavior inconsistent with normal functioning. According to his testimony, Ms. Powell was departing further and further from reality and decompensating into a full-blown psychotic state at that point. By the time she arrived at her home on the date of the murder, she was in the midst of a full-blown psychotic episode. Dr. Reardon testified that manner of BP's death influenced his opinion about whether Ms. Powell appreciated the wrongfulness of her conduct, noting that it demonstrated the incredible magnitude of the loss of reality and the loss of any ability to engage in any any reasoning or conscious thought during those moments. Dr. Thomas Swales, a forensic neuropsychologist employed by the Cuyahoga County Court of Common Pleas Psychiatric Clinic, also testified as an expert for Ms. Powell. Dr. Swales explained that he based his evaluation of Ms. Powell on a structured clinical interview, a format in which he has been tested against other psychiatrists using the same tools to see if we come up with the same answers. He opined that at the time of the offense, Ms. Powell was suffering from a first episode of schizoaffective disorder, bipolar type, and was in an acute psychotic state that impacted her ability to know the wrongfulness of her actions. According to Dr. Swales, Ms. Powell was living delusion and was completely, totally out of her mind. Living a delusion, was completely and totally out of her mind. With respect to malingering, Dr. Swales acknowledged that Ms. Powell was slightly over the threshold score for possible malingering on the Miller Forensic Assessment of Symptoms test, but he explained that the assessment is not a diagnostic tool. Dr. Swales also administered the structured interview of reported symptoms, second edition, the medical symptom validity. Dr. Swales also administered the structured interview of reported symptoms, second edition, the medical symptom validity test, and the nonverbal medical symptom validity test. He testified that malingering was not indicated as a result of those assessments with a high degree of certainty, and noted that a diagnosis of malingering in this case would not make sense. Dr. Swales also noted that he would not diagnose malingering without administering those diagnostic assessments. Ms. Powell's third expert witness was Dr. Robin Belcher Timmy, I'm not sure how to pronounce that, a licensed psychologist with an independent practice in forensic psychology. Dr. Tim spent approximately 5 hours conducting a clinical forensic interview of Ms. Powell, and he administered the MMPI, third edition, and the Miller Forensic Assessment of Symptoms to test her. He testified that at the time of the murder, Ms. Powell was suffering from a first episode of acute schizoaffective disorder, depressive type, and that her symptoms were so severe that she did not appreciate the wrongfulness of her actions. He characterized Ms. Powell's condition on that date as first episode psychosis and acknowledged that her case was atypical because she did not have a long history of psychosis and indicators of future violent behavior were absent. With respect to her behavior prior to the murder, Dr. Tim explained that when somebody is psychotic, it is a symptom to not believe you are psychotic. He testified that Ms. Powell's first semester at Mount Union was characterized by social anxiety, followed by a separation from reality that developed over time to the point where she's created a separate reality and is untethered from the world as we all know it. Noting that the state's expert analyzed Ms. Powell's cellular phone usage from the week before the murder, Dr. Tim explained that psychosis manifests and abates over time, offering opportunities for her to desperately hold on to some sense of normalcy in her life. Dr. Tim explained that Ms. Powell's behavior after the murder could be explained by the fact that she remained in a psychotic state, or in the alternative, that she was experiencing moments of lucidity that induced a trauma response. Dr. Tim testified that Ms. Powell's medical records from the weeks after the murder indicate that those who treated her uniformly recognized that she was suffering from a severe mental illness. This is after the murder. He also testified that Ms. Powell's score on the Miller Forensic Assessment of Symptoms test fell below the threshold that suggests the presence of malingering, and that he did not observe indications of malingering during his evaluation. He also emphasized that because the consequences of being characterized as a malingerer are so serious, he would not make that diagnosis without administering diagnostic assessments. The state called a single expert witness, Dr. Sylvia Obradovich, to testify regarding the not guilty by reason of insanity defense. The expert report that Dr. Obradovich prepared reviewed Ms. Powell's recent social history in conjunction with collateral records that included her cellular phone usage, and academic records from Mount Union. Dr. Obradovich's report noted that during the 2 hours that she spent interviewing Ms. Powell was less than honest and forthcoming. Dr. Obradovich observed that Ms. Powell tended to respond vaguely, omit or distort relevant details, or assert that she was unable to remember or did not know the information that might reflect her in an unfavorable light. Dr. Obradovich also noted that Ms. Powell, quote, tended to exaggerate or feign having symptoms of a severe mental illness that she claimed rendered her unable to function, end quote. In the course of her report, Dr. Obradovich summarized Ms. Powell's cellular phone activity during the week that preceded the murder, the information gained during the police investigation, and Ms. Powell's medical records. Dr. Obradovich opined that Ms. Powell did not meet the criteria for a severe mental illness at the time of the murder, that her symptom presentation is not credible, and that she appreciated the wrongfulness of her actions at the time of the murder. Dr. Obradovich's report did not explain her methodology in detail or comment on the methodology employed by Ms. Powell's experts. During her testimony, Dr. Obradovich summarized the conclusions contained in her report. She also distinguished her methodology from the methodology employed by Ms. Powell's experts, explaining that in clinical work, you take what's reported to you and you just assume that it's 100% honest. There's no reason to lie. She then noted that her approach was slightly different. I took everything that was reported to me, I compared it with all the things we know to be true, and it did not add up to schizophrenia or insanity at the time of the crime. Dr. Obradovich explained that she examined Ms. Powell's cellular phone records because the best source of information for an insanity evaluation is all of the data and evidence for that time frame. So the best way to know what someone's mental state is by the things they were doing and saying at that time. Dr. Obradovich explained that she did not administer any assessments to Ms. Powell because they would be irrelevant to determining her mental state at the time the murder was committed. During cross-examination, Dr. Obradovich reiterated that a present mental health problem has no bearing on mental status at the time a crime is committed. She also summarized the difference between her methodology and the methodology employed by Ms. Powell's experts. Question. Okay, so Dr. Swales, Dr. Reardon, and Dr. Tim, they have a combined 50 years experience. Combined, they did 25 different psychological tests. And you are saying to this jury, you are not taking issue with the way they scored those tests, right? Answer, no. My issue is what's being given. When you have data, you have to determine how important and how credible that data is. And so our difference of opinion is clear, but I think that the approach was also pretty different, which is that my investigation and all of the time for the evaluation was spent on the time period of the crime. Whereas they took lots and lots of data from the time period of meeting with her, which, unfortunately is not the most relevant data. Question. Yeah, you're saying she was malingering and that these 3 doctors missed it? Answer. I'm saying these 3 doctors focused and believed everything she said, and I compared everything she said to what we know to be true, and it didn't match. Regarding the administration of assessments designed to diagnose malingering, Dr. Obradovich opined that assessments can only diagnose malingering at the moment the test is given, and that no assessment can indicate past malingering. Dr. Obradovich's testimony, therefore, did not only describe her conclusions about whether Ms. Powell met the criteria for not guilty by reason of insanity. Without question, Dr. Obradovich disagreed with Ms. Powell's experts on that ultimate issue. Her testimony went beyond that question, however. She also described her own methodology and offered pointed critique of Ms. Powell's experts, characterizing the bases of their expert opinions as both fundamentally flawed and irrelevant to the question at hand. These matters were addressed for the first time in the state's case in chief regarding not guilty by reason of insanity, and testimony rebutting these arguments would not have merely reiterated matters brought in Ms. Powell's case in chief. Ms. Powell was not required to preemptively counter these arguments. Considering that Dr. Obradovich did not include the critique in her expert report, and the state's cross-examination of each expert was minimal, it may well have been impossible for Ms. Powell to do so in any event. Interesting, it was not in her original report, in her expert report. Ms. Powell's proffered rebuttal, therefore, would have been evidence given to explain, refute, or disprove new facts introduced into evidence by Dr. Obradovich. The trial court denied Ms. Powell's motion based solely on the conclusion that there had been lots and lots and lots of expert testimony in this matter. Under these circumstances, however, Ms. Powell had an unconditional right to present rebuttal testimony. This court therefore agrees that once the state's expert had testified, the trial court erred by denying her the opportunity to present rebuttal testimony on not guilty by reason of insanity. Ms. Powell's first assignment of error is sustained on that basis. So they are overturning her conviction. Saying that the trial court erred in refusing to allow the defense to put up a surrebuttal. Assignment of error 2. That argument was that Ms. Powell's convictions were against the manifest weight of the evidence. Assignment of error 3. That argument was Ms. Powell's right to a fair trial under the 6th and 14th Amendments and Ohio Constitution, Article 1, Section 16, was violated when the prosecutor made improper remarks and solicited testimony regarding her desire to consult counsel. Assignment of error 4. That argument was the trial court committed prejudicial error when it denied Ms. Powell's motion in limine and permitted gruesome photos and testimony regarding the victim's cause and manner of death, which were not in dispute. Court goes on to say, Ms. Powell's second assignment of error is that her convictions are against the manifest weight of the evidence. Her third assignment of error argues that the state engaged in misconduct by commenting on her desire to remain silent after her arrest. And her fourth assignment of error argues that the trial court erred by admitting evidence that was irrelevant or unduly prejudicial. In light of this court's resolution of her first assignment of error, her second, third, and fourth assignments of error are moot. Ms. Powell's first assignment of error is sustained. Her second, third, and fourth assignments of error are moot. The judgment of the Summit County Court of Common Pleas is reversed, and this matter is remanded to the trial court for proceedings consistent with this opinion. Judgment XOXO, judgment reverse, and cause remanded. Case remanded. And then it says there were reasonable grounds for this appeal. We order that a special mandate issue out of this court, directing the Court of Common Pleas, County of Summit, State of Ohio, to carry this judgment into execution. Certified copy of this journal entry shall constitute the mandate pursuant to Appellate Rule 27. Immediately upon the filing hereof, this document shall constitute the journal entry of judgment. It shall be stamped by the clerk of the Court of Appeals, at which time the period for review shall begin to run. The clerk of the Court of Appeals is instructed to mail a notice of entry of this judgment to the parties and make a notation of the mailing in the docket pursuant to Appellate Rule 30. Signed, Judge Jennifer Hensall, Hensal, for the court. There are two judges concurring. And this is a wild turn of events in the Sidney Powell trial. The attorneys did comment today, and of course it's the day after Christmas, also known as Boxing Day. And so the news on this has been kind of scant. But I think I did find some comments from the attorneys. One of Sidney Powell's defense attorney, Don Malarchik, said that Powell's family is ecstatic and hopeful. He said, people like Sidney who suffer from a serious mental disease do not belong in prison. I look forward to working with our newly elected prosecutor to ensure Brenda's death is no longer used for political purposes. Attorney Jeff Laybourne, who represents Powell's family, echoed Malarchik, we will continue to support Sidney moving forward. The prosecutor's office is aware of the 9th District's decision, which only addresses the trial court's procedure and not the defendant's guilt, wrote interim director of community Rick Raley, also an attorney who argued during the appeals case for prosecutors. We are currently considering options on how to proceed. And this is according to the Beacon Journal. So it seems like the prosecution has not decided whether or not they're going to retry her, but this is going to go back to the trial court for further proceedings. Interesting decision, interesting turn of events on the Sidney Powell case. So let me know what you think in the comments below. This case has given me some real Carly Gregg vibes, except Carly Gregg was 14. She's been sentenced to life in prison without parole, tried as an adult in Mississippi. And Sidney Powell, who was 19 at the time of the crime, is being granted a new trial. A lot of similarities, if you ask me. Until next time, my friends, stay cool, stay kind, stay classy. I'll see you real soon. Peace.